Title 26 is the Internal Revenue Code. It's never been enacted into law. It's a regulation. Can you get it? Can you get it? See that? Look closely. Title 26 and Title 27. Do you see an asterisk there? You don't see one, do you?
No, sir.
That's because there ain't one. Now, let's look at the other version. The other version is exactly the same. And this is the one out of the official U.S. reports for titles. And this one says, can you get my pen? You tell me when.
All right, sir.
Okay. This title has been enacted as law. Look at all the titles that got an asterisk. You'll notice again, Title 26 and Title 27, Zippo. No asterisk. Everybody see that? Real clear? Pull it over. No asterisk. Obviously, it's never been enacted as law. How could it be? I'll tell you how. We got a case over here called Erie Railroad versus Tompkins, and I'm going to bring it to your attention. Erie Railroad versus Tompkins is a magnificent court case. Basically, what this court case did, this court case is recorded at Volume 304, United States Reports, page 64. This is the start of the case. That's 304, Volume 304, United States Reports, Section 604. Now, what this case does is it sets up a duality of citizenship. There are the citizens that live at the citizenship. There are the citizens that live at the common law, and there are the citizens that live at the national law, or what is called Admiralty and Maritime Jurisdiction. Now, the way they get away with putting this Title 26 and this Title 27 out, the way they do it, is they create this Admiralty and Maritime Jurisdiction, and if you volunteer into it, you are in it. If you step in it, it's on you. Okay? So I'm telling you, don't do that. You know what the doctor says? Every time you go to the doctor and you say, Doc, every time I do this, it hurts. You know what the doctor tells you? He says, don't do that no more. You don't do that no more, it won't hurt, right? I'm telling you the same thing applies with this. Don't volunteer. How do you volunteer? You enter and you watch what you sign, number one. Any evidences of contracts where you are in Admiralty or Maritime Jurisdiction says that you are a party to the contract. So you avoid that. When you sign that bank draft to get into that bank and that Section 9 form you fill out, guess what? Look at the bottom. You sign to get into an Admiralty Maritime Jurisdiction. What the hell would you want to do that for? It's illogical. When you signed up for that Social Security check. So, how are we going to remedy this situation? 1-207. Without prejudice. You sign anything that has to do anything with those guys, take the rights if they'll give them to you. Take the benefits. But make sure when you sign it UD 1-207 without prejudice. And that makes you a common law citizen. And when they pull you into these courts and they claim they have jurisdiction over you, you say, the first thing out of your mouth is, Your Honor, may it please the court, before this matter goes forward, I wish to state that I am here on a special appearance as distinguished from a general appearance, and I am answering in the form of a demurrer. A demurrer is an old way of pleading. It's an old-fashioned, old-country, barrister English way of pleading without granting jurisdiction. In other words, I'll answer out of courtesy, and I'll give you an answer out of courtesy, but at no time am I granting jurisdiction. Now, I put on my briefs, I state my name, I state the defendant in propria persona, on a special appearance is distinguished from a general appearance for jurisdictional challenges. Now, I've raised the issue of jurisdictional challenges. I'm putting on the record. It's clearly cognizant. Once jurisdiction is raised, the burden is on the plaintiff to prove jurisdiction pursuant to McNutt v. General Motors Acceptance Corporation, recorded at 56 Supreme Court 502. It says, jurisdiction may never be assumed, but must be substantively proven by the plaintiff claimant. They don't prove it in a timely fashion, laches incurs. Laches is a species of action wherein a party of reasonable intelligence and integrity having a right to take an action as is prescribed by law, and having failed to timely do so, loses all right to proceed. So if they don't prove it timely, motion to dismiss, Your Honor, failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous case. Does that make sense to you? All right, now, let's get into this Erie Railroad case. This is a railroad case. What it's about, it's a guy was walking down the track and a board was hanging off the end of the train and whacked him upside the head. He tried to sue in the state courts. The state courts hammered him. So what happened was Erie Railroad had flipped around and they tried to sue him in the federal courts to get back at him. And they thought they were pulling a fast one. And what happened was the case bounced back on them. And guess what? When it bounced back, it created a very, very dangerous thing. Now, before this, I want you to understand that for 100 years of law, this case was the one that was the leading case before this. And this was called McCulloch versus Maryland, the state of Maryland. This is a very leading case. This is the most heavy case. It comes in 2 sections. That tells you how thick it is. So you're going to be reading for a while. This case upheld for 100 plus years, practically almost 100 years. This case is recorded at, where are we at here? Where is the site? The site is, come on, give me a break. It's page 316. What is the volume? You guys are messing with me. You see a volume in there? Well, let's see what they call out here. They call up the beginning of the case. Well, we'll get you the volume. I should know it by heart, but I don't. Let's see if we can get it. It's an 1819 case. It is an old case. And it upheld for years the single citizenship relationship. And it deals with corporations. The power of establishing a corporation is not a distinct sovereign power or end of government, but only the means of carrying into effect other powers which are sovereign. Whenever it becomes an appropriate means of exercising any of the powers given by the Constitution to the government of the United Union, it may be exercised by that government. Now, basically, it sets up relationships. The Bank of the United States has constitutionally a right to establish its branches or other offices in discount and deposit within any state. All right? The state within which such branch may be established cannot, without violating the Constitution, tax that branch. All right? Now, it goes into some heavy arguments on taxes and some other arguments on programming. But I'm telling you here, this was the law of the land. I want to get a cite on this for a reference. This book was so old when we got it from. It should say what volume it is, but it doesn't. Normally they put it in the case and then they'll cite it one time and then they'll say everything after that, supra. They stated it at the beginning. Alright. Volume 4. Volume 4. No, wait. That's not really a good... That's probably... See, these reporters in the early... This is 1819, folks. That's when this case came down. So this was going to be, shortly after the Constitution was signed. 1791 is when the Constitution was signed, so it's going to be an early case. All right, William McCulloch, defendant, below in your branch. Normally they state the case one place and they state it. But anyway, to make a long story short, McCulloch versus Maryland is a very heavy case. It was the law of the land, and it was replaced by Erie Railroad versus Tompkins. There is no federal, can you see that? There is no federal general common law. Congress has no power to declare substantive rules of common law applicable in a state, whether they be local in their nature or general, whether they be commercial law or in part of the law of torts. And no clause in the Constitution purports to confer such a power upon the federal courts, except in the matters governed by the federal Constitution or by acts of Congress. The law to be applied in any case is the law of the state. Got me? And whether the law of the state shall be declared by its legislature in a statute or by its highest court in a decision, not a matter of federal concern. Now, in disapproving the doctrine of the Swift versus Tyson, the court does not hold unconstitutional Section 34 of the Federal Judiciary Act of 1789 or any other act of Congress. Title 26. It merely declares that by applying the doctrine of that case, rights which are reserved by the Constitution to the several states have been invaded. That's why they can get away with having Title 26 without having no asterisks. They don't have to have it in law. They're claiming it's an act of Congress. And if you voluntarily enter into it, guess what? You bought the whole farm. A federal court exercising jurisdiction over such a case on the ground of diversity of citizenship. What am I talking about? Diversity of citizenship. I'm talking about dual citizenship, right? Is not free to treat this question as one of so-called general law, but must apply the state law as declared by the highest state court. Swift versus Tennyson, overruled. The liability of the railroad company for the injury caused by negligent operation of its train to its pedestrian on a much-used beaten path on its right-of-way interstate, right, along and near the rails depends in the absence of a federal or state statute upon the unwritten law of the state where the accident occurred. Now, what they're trying to do here is they're trying to justify the existence of this duality of citizenship between common law citizen, which you are, most of you, and this natural national citizen, which would fall under Title 26 United States Code. But I'm telling you to look up Section 6331A of Title 26, and you will see that the Secretary of Treasury has jurisdiction only over corporations, officers of corporations, and officers of government residing in the District of Columbia and artificial corporation, who are contractors of the fund. Capiche? All right? Now, this is an important case. If you guys are going to be in this seriously battling and want to argue jurisdiction, which is a very good defense on almost anything they can pull on you, you're going to have to read these cases. Erie Railroad versus Tompkins, recorded at 304. That's volume 304, U.S. Page 64 is where it starts. It's vital that you understand these arguments. I just finished battling a United States attorney, and we were arguing, and he's talking about this is all gibberish. And I told him, I said, sir, I don't think you're well read on the law. All you got to do is read several of these cases, and they'll tell you, 1, there is a duality of citizenship. 2, it has to be clearly defined. And 3, I have defined it. And now I'm asking you to prove that I'm not a party. Or prove that I am a party. You tell me. It's your burden. You're the one making the complaint. You make the complaint, you get the burden of proof. Who says so? McNutt versus General Motors Acceptance Corporation, 56 Supreme Court, Section 5, or page 502. You made it, you prove it. Okay? You don't prove it timely, I motion to dismiss. Failure to state a cause of action for which relief can be granted, and I will beat your little tail. So I would highly recommend you get to busy to proving it. Now, if you think the stuff don't work, let me tell you something here. Right today, government came, told me, motion to dismiss, right? United States of America hereby moves, pursuant to federal rules of criminal procedure, for leave to dismiss the indictment in the case support the statutes, okay? Now, they can't argue. Give me a certificate of service. Order dismissing indictment, which the judge will sign. The government having moved to dismiss the indictment in the case of this court being fully advised in the premise that is ordered in the indictment of B and the hereby is dismissed with prejudice, and that the defendant's bond is canceled, it is so ordered and adjudged. Wherefore the United States requests that this court enter the attached order dismissing the indictment without prejudice, but we'll figure that out. We'll fix that up. See, I don't care if we go to court, because I know who's going to win. And I pray to God that He'll help me do that. So if they want to go to court, I tell them, make my day. When I'm in the court, the guy says to me, well, we could get you for an income tax evasion, and you might win one, but you won't win them all. I looked at him most calmly, and I said to him in the clearest and gracious language, I said, sir, I'm going to advise you to go look in them law books real carefully, because I'm going to tell you straight arrow, I have had occasion to look in them law books. And I'm telling you, sir, if you bring that complaint against me, I'm going to tell you to make my day. Because I'm a pretty serious fellow, and I'm not going to fool with you. I'll sue your socks off and attach everything you own, bank, business, and home. So, the best thing I can tell you is before you make a complaint, sir, I would highly recommend that you seriously consider the merits of your facts before you go writing a bunch of dribble. And when we got him today, he's talking about, well, your briefs are nothing but gibberish. So we asked him, he said, well, on our proposed order to have it dismissed, do you want us to put it down there for good gibberish shown or just generally good cause shown? So he got a little red in the face and stormed out. But the bottom line is, if you know your facts and you got your stuff together, I'm telling you people out there in TV land, you can do this stuff. As God is my judge, I'm a truck driver. I've been an engineer for a while. I'm a fisherman, a hunter, and a guide. I'm a regular person. I just read a lot. Okay? I know people like to add stuff in the game, but I'm a regular citizen of the United States. I love my country and its Constitution. And I'm not fooling around. I want them to honor my Constitution, and I don't think that's too much to ask. I think a lot of fine soldiers paid for it. We've had a lot of patriots. Some of the finest people I've ever known have paid for it. I especially tout Donald Costu, who was the editor of the Constitutionalist newspaper and the initiator and starter of the Justice Pro Se movement in this area. He was a great man. He was a courageous man. He was found shot to death in his home with a bullet in his nose because obviously he stuck his nose in places it shouldn't have ought to been. He was a tireless defender of the people and the Constitution. Many a time we cruised the countryside doing meetings hither and yon. He wore a white cowboy hat, which we used to joke about. Good guys wear white hats. He was an exceptional personality. He lost everything he owned, fighting to the death. And I especially offer my serious prayers for his soul, and for the soul of all patriots who have suffered tremendous things to put on this Constitution and to keep us going. The people with the WWCR radio there, God bless you. Radio Free America, Tom Ballantyne, Bill Cooper, the infamous Jack McLam from Vampire Killer 2000. There's serious battlers out here, folks, myself included. There's quite a few patriots all around. I can't tell you the names of the people that I feel absolutely privileged to know because the list would be so long here it would take another 2 hours just for the tape. But I can tell you some exceptional people, and some of them are on bond and they can't be doing that, so I'm respecting their, some of the things. The infamous Eugene May, E.J. May. There's just so many. The infamous No Tax Jim, James Gordon Lott. The names are endless. So I'm telling you folks out here, there's a lot of good people out here that are pulling for you, that have risked a whole lot, have gone to jail, have stood out in rain protesting. The infamous Dave Franklin, who was one of the most leading arguers on constitutional issues of admiralty and maritime jurisdiction. The outstanding Art Morris, who published the book The Greatest Swindle Ever Told, which is about 4,000 pages of documentary evidence on income tax situations. We're going to share you a couple of arguments in the end, and then we're going to kind of close it off here until the next time. But I want to thank you very much for inviting me into your home, and hopefully we haven't bored you to tears, and at the same time you will have a new love of your Constitution and your country, and that you will push like hell to make sure these people understand, hey, this is America, pal. Last time I checked, there's a flag on a pole out there, and that's an American flag. We don't want no blue flag out there. We want that American flag out there. And we got a Constitution, and we're going to keep it. If you don't like it, move. Preferably someplace out of here, like Russia or other places. If you like that kind of government, go for it. Knock yourself out. That's what free America's all about. You got a right to any idea you like, just so you don't injure your neighbor. You got a right to free speech, but you can't yell fire in a crowded theater. Got me? Does that make sense? Okay. If you don't like it here, move. You don't want to exercise your constitutional rights, that's your prerogative, but if you get abused, don't say we didn't tell you. Because God kind of wants us to do this thing, because this is His holy land, and He's hoping that we're going to have enough hair on our tail feather to do it. Now, I want to get into a couple other arguments. One of the things I want to tell you about is procedure. You're going to go to court, and you're going to be your own attorney. By the way, this is the infamous No Tax Jim. He just died, God rest his soul. The infamous James Gordon Lott. I helped the gentleman do his appeal briefs to the U.S. Supreme Court, and I can tell you he was one hell of a gentleman. He can quote Tragedy and Hope, Quigley's Tragedy and Hope from the hip, from memory. And he just passed away. Just recently he died. I want you to see how he died, too. Where does it says? He was alone when he died, Monday, and no services planned, and they cremated his body. He fought to the end. To his last day, he was on the Mark Scott program. There's another exceptional patriot, Mark Scott. I can't speak highly enough for the courage it takes to come on the radio and tell God's truth. There's a lot of people like him. Tommy McIntyre, Mike Reagan. We could get you a list a mile long. There's patriots that come on and tell it like it is. J.P. McCarthy is another one that gets on there and tells it like it is. I remember this one casual time he got Gus Hall on, and J.P. said to Gus Hall, he says, "Gus, don't you get tired of losing?" Because Gus was running for president on the Communist Party ticket. And Gus, "Don't you get tired of losing?" Because Gus was running for president on the Communist Party ticket. And Gus turned to him and he said, "J.P., what makes you think we're losing?" He said, "We've implemented every plank of the Communist Manifesto. We just haven't got the guns from the people yet." And J.P. turned to him and said, "Yeah, and you ain't going to get them from the people. What do you think of that?" Well, folks, what do you think of that? They're working on it, aren't they? Huh? Now, you're going to go to court and you're going to be your own attorney. You got to be sharp. You got to keep records. You go to court, you write it down. You get anything in paperwork, you write it down. You send them anything in paperwork, you write it down. You got me? Don't be screwing around on me, because I'm going to tell you some of these things got dates and times and things that you got to do. And if you don't take care of business, guess what? They ain't going to take care of it for you. You're your own attorney. If you want to be your own attorney, you got to have records. You got to keep on top of things. So every time you do something, you write it down. And you make sure you can go back and say, "Yeah, I remember on such and such a date at such and such a time this happened and this happened and this happened." You can construct a chronological order of events, okay? Now, also write down all important numbers to anybody that has anything that's got to be done. Okay, now, what we want to get into is we want to get into some serious arguments on taxes. Okay? And also, we should tell you that if anybody violates your rights, okay, Title 42 United States Code, Section 1983. Everybody got this? Can you see it? Every person who, under color of statute, ordinance, or regulation, custom or usage of any state or territory, or the District of Columbia, subjects, or causes to be subjected, any citizen of the United States or other person within the jurisdiction thereof, to the deprivation of any rights, privileges, or immunities secured by the Constitution and the laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for the redress, for the purpose of this section, any act of Congress applicable exclusively to the District of Columbia. Why do you think they said that? Because they're members of the fund. And they are under Title 26, Section 6331A. Shall be considered to be a statute of the District of Columbia. Now, does everybody understand about Admiralty and Maritime Jurisdiction? I know you don't, but not a little bit. They have created a duality of citizenship under the 14th Amendment. They're claiming there's common law rights, which everybody gets their Constitution, and there's national rights where you waive all your Constitution. Now, which did you want? Does that sound like a good deal? Sounds like you're being ripped to me. Here we got the 1-207. Remember, 1-207, right? All right, now. Okay. Where are we at here? We want to show Jack McLam's magnificent books too. Vampire Killer 2000 and the Aid and Abet newsletter. We need to get these out to every police officer in the United States of America. They need to understand what the heck's going on here. You get a hold of Jack McLam and his people at Vampire Killer 2000 and they will be happy to put this book out. This explains to your police officers exactly what the heck's going on. And they have an Aid and Abet newsletter that you can get. Let's get that out. Aid and Abet. Aid and Abet Police Newsletter, P.O. Box 8787, Phoenix, Arizona, 85066, right? And he has a phone number you can call him too, I think. Now, they have these vampire killers out, and it tells the police everything they need to know. Also, they publish a newsletter, Aid and Abet newsletter. You want to make sure, Aid and Abet, okay? And get that to your police officers. What I like to do is when a police officer busts me for something, what I like to do is I like to enroll him in a free subscription. And you know what? He hands it out to everybody. Plus, I'm doing him a service. Now, if you folks don't think this is serious, I'm telling you right now, they are building these work camps, these multi-jurisdictional forces, and these work camps all over. Notice that most of them are coordinated between Michigan, Indiana, Ohio, and Wisconsin. And then they got a bunch more out here in the Wyoming, Idaho, the Great West, and they got them in California. Then they got these detention facilities. Everybody paying attention to these detention facilities? Notice where most of them are, and what they call them is regional prisons. Look at all the ones here in Michigan, Indiana, and Ohio, or Illinois.
There's a bunch of new ones since then, too.
Yeah, there is. I know there is. They prop up and they call themselves... Okay, and then they got battle groups, United Nations battle groups. I mean, we've had reports of Russian troops being in Michigan all summer. And we got positive sightings by people that are retired military colonels and above. And we know they were at Camp Grayling this summer. So I'm telling you folks, the time to wake up is now. Wake up, America, before it's too late. Before you lose your God-given rights to some foreign potentate who might think that you look like a sucker. I mean, you want to buy any apples off that cart? I ain't buying no apples off that cart because I know they're all rotten. Okay? Now, we want to get into...
Militia?
The next thing we want to get into is the militia, right? And then we want to get into taxes seriously. And that'll be the close for today. Now, those of you who have been in militia groups and everybody's getting all panicky, let's understand a few things about the militia. Whether you like it or not, you are in the militia in the state of Michigan. And I will tell you right where it says that. Article 17, militia, right here. What does it say? And this is from the 1850 Constitution. All the way back in our state to the Northwest Territories treaty, they have a militia. But this is an example of what they're talking about. The militia shall be composed of all able-bodied male citizens between the ages of 18 and 45 years, except such as are exempted by laws of the United States and of the state, but all such citizens of any religious denomination whatever who from scruples of conscience, all right? In other words, if you're a conscientious objector, may be adverse to bearing arms, shall be excused therefrom upon such conditions as shall be prescribed by law. And they have conscientious objector statuses, okay? Then you go to the 1908 Constitution, just to show you that this is the God's truth here. 1908 Michigan Constitution. The Michigan militia shall be composed of all able-bodied male citizens between the ages of 18 and 45 years of age, except such as are exempted by laws of the United States or of this state. But all such citizens of any religious denomination who, from scruples of conscience, may be adverse to bearing arms, shall be excused therefrom upon such conditions as shall be prescribed by law. Okay? Now, that's the 1908 Constitution. Now you come up here. Now this just lets you know the trend. The trend here. Now, we're in the 1963 Constitution. And in the 1963 Constitution... Oh, wanted to show you a little diverse thing here. This right here. Common law and statutes in continuance in Michigan. The common law and the statute laws now in force, not repugnant to this Constitution, shall remain in force until they expire by their own limitations or are changed, amended, or repealed. So the common law is prevailing. The militia, here we go. I knew we'd seen it. Now notice, folks, as the thing goes on, it gets shorter and shorter. Here's your militia. This is Article 3, Section 4. The militia shall be organized, equipped, and disciplined as provided by law. That's all you get now. Now, when you look in the beginning of this Constitution, there is a empowering statutory phrase that says, all constitutions before, everything they had in them are carried forward to this Constitution. And that's how they're allowed to do this. So what would happen in this case, because they haven't clearly defined it here, they would have to go back in the law to the previous Constitution, which would be the 1908 Constitution, which we just read to you. Well, this one right here. So this one would be the militia shall be composed of all able-bodied male citizens 18 to 45 years of age. So that would be the controlling one, because that's as prescribed by law, just like they said. Does everybody see that? Now, the bottom line here, folks, is a lot of people are all upset about the militia. All the militia is concerned citizens that are worried about their Constitution getting flushed down the toilet. We're not putting up with that stuff. We want people to understand that we love the Constitution, we love our country, and we're not screwing around. All right, here we go. Generally, the militia shall be organized, equipped, and disciplined as provided by law. Now let's get into that. The single section is substituted for all of this relating to the militia in the present 1908 Constitution. Remember I told you about empowering? The existing article ties the legislature down to an outmoded concept of what the militia should be. You believe that? Boy, our forefathers would be rolling over in their grave. Details as to organizing, equipping, and disciplining the militia are left to the legislative enactment in the interest of the flexibility and future requirements. Does that mean future requirements, if it got nasty and down and dirty, we would have our militia come back? Sounds good to me. I could go for that. The bottom line is the people that know what's going around are not screwing around. They join the militia. Okay? Alright, now Article 10. Alright, here we go. Here we go. Article 9. Let's pull this out. The militia, organization and discipline. The legislature shall provide by law for organizing and disciplining the militia in such manner as they shall deem expedient, not incompatible with the Constitution and the laws of the United States. But they're not doing it, right? The legislature shall provide for efficient discipline of the officers commissioned and non-commissioned, and that musicians and/or may provide by law for the organization and discipline of the volunteer companies. Volunteer companies. Notice that. Volunteer companies, huh? Officers of the militia shall be elected or appointed in such manner as the legislature shall from time to time direct and shall be commissioned by the governor. The governor shall have the power to call forth the militia to execute the laws of the state, to suppress insurrections and repel invasions. That's what our forefathers had in mind when they had a militia. Now, if they're going to invade us, they're going to change our money, they're going to shut down our Constitution. That's why the militia needs to be organized. That's why you need to be down there talking to a militia. That's why you need to be joining the militia. I don't care what church you go to. I don't care what color, national origin, ethnic background you come from. You need to be down to the militia, and you need to be talking to them folks about this is the United States of America, and I will protect it and its constitutional form of government. And by doing that, if we do it in sufficient numbers, most probably what will happen is the New World Order scammers will realize, the people woke up, we screwed up. We'll have to wait another 300 years to try and pull it again. And let's hope that's what happens. If that isn't what happens, then the militia will defend the Republic, just like what our forefathers intended. And we will defend the Republic, as we always do, with vigor. And we will have a government by Constitution. That American flag will be on that pole out there, and anybody that wants to try something different, hey, knock yourself out. but planning a very severe battle, because we will never give up the United States of America, its constitutional government, or our American flag, or our American heritage. So this idea that you're going to wear us out, tie us down, otherwise skew us around is nothing but a lot of hoodoo. It ain't going to happen in your lifetime. As a matter of fact, your lifetime may not be that long either. Because we try traitors in this country. And the bottom line is the penalty for treason is death. And it's not our purpose to threaten or coerce or otherwise intimidate any person, but we want you to understand that this is the United States of America. This is a country governed by constitutional law, that constitutional law prescribes penalties for criminal acts, and that those criminal acts can be punished by a lawful means. We're asking all persons that are involved in all walks of government or any areas of the law to please, 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 let's get back to the Constitution and quit screwing around. Let's just get back to what's supposed to be done and quit screwing around. Pull back your Federalist Papers and let's start reading. You're going to find out everything that's in this book is directly applicable today. We need to do it over. We need to get back to a gold and silver standard. We need to get back to a serious means of trade expedience that's going to hold the standards of our country even. We won't have this inflation. We won't have this ridiculous market situation. We're asking you, please, before God, we're asking you. We want our Constitution. We want it back. We want all of the American principles that we stand for, that our brave soldiers died for. And we're asking you to please quit screwing around. Let's get down to brass tacks. You've been feeding the pablum to the babies too long. Believe me, we're way ahead of you. You may not think so, but I'm here to tell you, we're way ahead of you. You're going to wake up someday and you're going to be shocked. We're going to be all standing out there smiling. Because you're going to be the one that's asleep, not us. We know what we're talking about. We're not fooling around. We want you to honor our Constitution. God bless America. We want you to keep us safe. We want to be into the 21st century stronger than we were in the 17th century. We're not fooling around, so please. Now we can go into this book, and this book clearly establishes they never wanted to have a militia or a standing army. They only trusted. You listen to some of these arguments in here. Okay? But it is said that the laws of the Union are to be the supreme law of the land. What inference can be drawn from this, or what would they amount to if they were not to be supreme? It is evident they would amount to nothing. A law, by the very meaning of the term, includes supremacy. It is the rule which those to whom it is prescribed are bound to observe. This results from every political association. If individuals enter into a state of society of laws of that society must be the supreme regulator of their conduct. If a number of political societies enter into a larger political society, the laws which the latter may enact pursuant to the powers entrusted to it by its constitution must necessarily be supreme over those societies and the individuals of whom they are composed of. It would otherwise be a mere treaty dependent on good faith of the parties, and not a government, which is only another word for a political power and supremacy. But it will not follow from this doctrine that acts of larger society, which are not pursuant to its constitutional power, but which are invasions of the residuary authorizes of the smaller societies, will become the supreme law of the land. These will be merely acts of usurpation, which is kind of what's going on, and will deserve to be treated as such. Hence we perceive that the clause which declares the supremacy of the laws of the Union, like the one we have just before considered, only declares a truth which flows immediately and necessarily from the institution of the federal government. It will not, I presume, have escaped observation that it expressly confines the supremacy to laws made pursuant to the Constitution, which I mention merely as an instance of caution in the convention, since the limitation would have been to be understood though it had not been expressed. Though a law, therefore, for laying a tax for a use of the United States would be supreme in its nature, and could not legally be opposed or controlled, yet a law for abrogating and preventing the collection of a tax laid by the authority of the state unless upon imports and exports, would not be the supreme law of the land, but an usurpation of power not granted by the Constitution. As far as an improper accumulation of taxes on the same object might tend to render the collection difficult or precarious, this would be a mutual inconvenience, not arising from the superiority or defect of the power. Now we want to get into some serious arguments here. We want to go to page 108, about the middle of the page. Except as to the rule of apportionment, the United States have indefinite discretion to make requisitions for men and money. That means they can ask. But they have no authority to raise either by regulations extending to the individual citizens of America. That's why we don't have a Title 26 that applies to you. The consequences of this is that, though in theory their resolution concerning those objects are laws constitutionally binding on the members of the Union, yet in practice they are mere recommendations which the states observe or disregard at their option. This is the intent of the framers. Cohen versus Virginia, 6/2/1821 says this is the exact intent. Is it pretty hard for you to understand what their intent was? They never intended to have an internal revenue. Ever. They hated people that operated like that operated a tyranny against the people. Alright, let's get on with this. Wise politicians will be cautious about fettering the government with restrictions that cannot be observed, because they know that every breach of the fundamental laws, though dictated by necessity, impairs that sacred reverence, which ought to be maintained in the breast of rulers towards the Constitution of a country, and forms a precedent for other breaches where the same plea of necessity does not exist at all, or is less urgent and palpable. Publius. And it teaches us, in addition to the rest, how unequal parchment provisions are to struggle with public necessity. You start reading. You got to read. Don't sit there like a bump on a log. Read. Get all kind of good stuff going here. I could sit here and read this to you all night. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in Constitution or laws of any state to the contrary is notwithstanding. The indiscreet zeal of the adversaries to the Constitution has betrayed them into an attack on this part of it, as also without which it would have been evidently and radically defective. To be fully sensible of this, we need only suppose for a moment that the supremacy of the state's Constitution had been left complete with a saving clause in their favor. In the first place, as these constitutions invest the state legislature with absolute sovereignty in all cases not excepted but the existing Articles of Confederation, all the authorities contained in the proposed Constitution. Remember I told you about how they tied them together? So far as they exceed those enumerated in the Confederation, would have been annulled. See that? And the new Congress would have been reduced to the same impotent condition with their predecessors. These people were wise way beyond their years. And this talks about the militia. They never wanted to have a standing army. Never. They always wanted the people to defend by a militia. They wanted the militia to be there ready to kick tail if there needed to be. They wanted to have a Paul Revere running down yelling, "The British are coming, the British are coming," or whoever. Somebody. They called them Minutemen. They call them Minutemen for a reason, because they wanted you to grab your kit and be out on the road in a minute, ready to kick tail and repel all borders. That's the way our forefathers thought. Now, they were wise men who had come from a tyrannical environment in the European marketplaces. They knew exactly what was going on, and they weren't screwing around. And the bottom line is they were deadly serious, and they were ready to sign their life. They pledged their life, their future, their fortunes, and everything so that we could have this Constitution. And I think we kind of owe them a debt, because a lot of them died miserably as paupers because they dared to sign the Declaration of Independence, and the king went after them with a vengeance. Do you understand? Now the bottom line here is we got a duty, and we're going to finish this thing up. We want to do some stuff on taxes, and then we're going to be out of here. We're going to do two things on taxes. One is going to be on Title 31 United States Code Section 742, and we're going to rattle it off. If you want the argument later, you'll have to get back with us, okay? Title 31 United States Code, and we're going to quote it. except as otherwise provided by law. All stocks, bonds, treasury notes, and other obligations of the United States government shall be exempt from state, municipal, and local authority. This exemption extends to every form of taxation that would require either the obligations or the interest thereon, or both be considered directly or indirectly in the computation of the tax. See Memphis Bank versus State of Tennessee et al. Garner. Notice this is Memphis Bank versus State of Tennessee et al. Garner. Everybody got that? That's recorded at volume 459, U.S., page 392. Okay, right here. Okay, can you see that? Okay. Now, what this case is this is a Supreme Court case that says that Title 31 United States Code Section 742 is the supreme law of the land. And it does so on a diversity of tax arguments based on discriminatory franchise of bond holdings. But basically what the Supreme Court said was Title 31 Section 742 was the supreme law of the land. And recorded right in here is exactly what I just quoted to you. Right here, except as otherwise provided by law. Notice it says all stocks, bonds, treasury notes, and other obligations of the United States shall be exempt from state taxation by or under state or municipal or local authority. Now what does this mean? What are they talking about here? This exemption extends to every form of taxation that would require that either the obligations or the interest thereon or both be considered directly or indirectly in the computation of the tax. This is a unique tax argument. See, when the states went off the Article 1, Section 10 gold and silver standard, you can't pay anyway. Because of Michigan Compiled Laws Act 21.153. You cannot tender anything other than gold or silver coin to an officer of the government without being a party to a felony. On top of that, how do they figure the taxes? Let's look at our property taxes. This is a big issue. A lot of people get involved with this property taxes. They're tired of being taxed right out of their home. This tax argument is specifically for you. They come to your house, they set a value on your house, they tell you that, your house is worth $100,000, so we're going to tax it at a 50% interest, which would be $50,000. That's a 50% amortization value. We'll figure your house is a $50,000 bracket area, and then we're going to go 7 points on that, 7%, or whatever the percentage is. Now, stop for a second here. How did they figure the value on your house? Well, they said $50,000. There is no dollars. What dollars? You ain't got no dollars. You got dollars? I ain't got no dollars. Dollars of what? Dollars of coffee beans? I don't think so. The bottom line is they talking Federal Reserve notes, and they're putting the commodity item at the reserve notes. Now, what did they just do? Except as otherwise provided by law. All stocks, bonds, treasury notes. What is a Federal Reserve note? It's a treasury note. And other obligations of the United States. What obligations? Title 12, Section 411 says the said notes shall be deemed to be obligations of the United States government. Whoops. Now wait a minute. Let's look at this again. Except as otherwise provided by law, all stocks, bonds, treasury notes, and other obligations of the United States shall be exempt from taxation by or under state or municipal or local authority. Does that mean they can't figure a tax by using obligations to the United States government? You're right. You're absolutely right. This exemption extends to every form of taxation that would require either the obligations or the interest thereon, or both be considered directly or indirectly in the computation of the tax. Now, what are they doing when they figure this 50% amortization of value, and then they add so many points percent on, and they attack that on, and then they say, well, you owe us this much? Aren't they using Federal Reserve notes indirectly? They are, aren't they? And they're forbidden from doing that. And the Supreme Court says this is the supreme law of the land. Well, guess what, folks? This case was originally brought in the matter of People v. Shepard out of Lansing. And after that case, they went in all the law books and they pulled out Title 31, Section 742. That's how scared they are of this title. And we went to Shepard Citations, and we noted that in Shepard Citations there was no note that says annulled, repealed, or otherwise transferred to some other law. There's a hole there, folks. It starts at Title 31, Section 734, and then there's a hole, and then it goes to 752. What happened here? They went in all the law books and pulled this argument out. Why do you think they did that? Because every state in the Union that went off the gold and silver standard under Article 1, Section 10 was locked out of taxing the citizenry in any capacity by the use of obligations of the United States government. That's the only thing you got in your hand, folks. So rather than play that game, they went in all the law books and pulled it out. Then they went in Shepard citations, and instead of putting a note down there as to what happened, they just created a void. What is that evidence of? Fraud. Fraud. Does not fraud void the contract? Last time I checked, it did. Now, I want you to pay attention to this stuff and get locked in on this argument, and don't try this until you've at least practiced a little bit. But anybody that's getting jammed on their property taxes or any other taxes for the state, lock their heels, is all I got to say. Okay? Now, we're going to go into one last argument on income taxes. And I'm not advising you as your attorney. I'm telling you what I have found as a scholar in the law books. I have found these arguments, and if you want to use them, that's your free choice. This is America. Last time I checked, you have a right under the Constitution. We've argued this before the Supreme Court, though, and it cannot be argued against. It's pretty strong. Bear with me a second here. My voice is going. Now, since the Constitution... Alright. Since the Constitution of the United States is the supreme law of the land, we got a unique argument here. It says in Article 1, Section 9, Paragraph 4, most clearly, no capitation or other direct tax shall be laid unless by the enumeration or addition hereinbefore directed to be taken, and that's in Article 1, Section 2, Clause 2, which says income taxes and representation shall be before directed to be taken, and that's in Article 1, Section 2, Clause 2, which says income taxes and representation shall be by apportionment, which I will show you. I like to show everybody the rules. Article 1, Section 2, Clause 2. Right? Just so everybody's on the same wavelength. Article 1, Section 2, Clause 2. Where are we at here? Article 1, Section 2, Clause 2. Representatives and direct taxes shall be by apportionment among the several states which may be included within the Union according to their respective numbers, which shall be determined by adding the whole number. Alright, we got the idea. Article 1, Section 9, Clause 4. No capitation or other direct tax shall be laid unless by the proportion to the census or enumeration as hereinbefore directed to be taken. Well, folks, they're not using the census. They're not using apportionment issue at all. They're evading it totally. Now, there's several arguments here, and it's very catchy, so I want you to pay close attention. All right? One of the arguments I want to share with you is brought by an infamous, outstanding judge, Judge Beers. He's the gentleman that actually lived the movie Cheaper by the Dozen. He went out and had 2 wives and had 12 kids by each. Man's got a lot of guts. All them kids went to college, too, I want to tell you. Every one of them. I know some of them personally myself. One of them is the director of the law library at Oakland County Court. Excellent people. The Judge Beers got mad, and he called up Jimmy Carter, and he told him, look, we need to have a raise for our judges because we're not keeping up with inflation, etc., etc. And Jimmy told him, no way, Jose. And so Judge Beers filed in court the case of Evans versus Gore, recorded at 253 U.S. 245. Judge Evans sued I.R. Gore of the Internal Revenue Service because he claimed that the Internal Revenue Service diminished his salary during his continuance in office. And we all know that judges of the Supreme Court and inferior court shall hold their office during good behavior and shall receive for their services a valuable compensation which shall not be diminished during their continuance in office. That's Article 3, Paragraph 1. Wait, I'm sorry. Let's see. Yeah, Article 3, Paragraph 1. The judicial power of the United States shall be vested in the Supreme Court and such inferior courts as may from time to time ordain and establish. The judges both of the Supreme Court and inferior court shall hold their office during good behavior and shall receive at stated times for their services a compensation which shall not be diminished during their continuance in office. Well, guess what, Your Honor? They diminished my salary during my continuance in office. You'll notice that there was no diminishment specified, so all diminishment is forbidden. Okay? And since all diminishment is forbidden, I am constitutionally immune from your income taxes. The Supreme Court came back and said, excellent argument. The 16th Amendment didn't create any new taxing power whatsoever, and clearly, Judge Evans is immune from income taxes based on the Article 3, Paragraph 1 constitutional immunity. So up jumped the devil in the deep blue sea. Jimmy Carter was most unhappy, so he had to give the judges all a raise to shut him up. And he took his wrath out on Judge Beers, and he went and published the fact that Judge Beers was a bigamist, and he kind of trashed him and got him disbarred and thrown off the bench, which I didn't think was a very nice thing to do at all, because Judge Beers was a good judge. Now, how does this affect you? Basically, this case of Evans versus Gore makes two basic statements. One, the 16th Amendment didn't create any new taxing power, and two, there was, what? An acceptable, possible immunity to the income tax, right? Whoa, I said. Let's go back to Article 1, Section 9, Paragraph 4. No capitation or other direct tax shall be laid unless by the rule of apportionment is hereinbefore directed to be taken. Didn't I have a right to be free from a direct tax on my property? A direct tax is one where I actually come in your pocket and I tax it. I had a right to be free from a direct tax on my property unless by the rule of apportionment is hereinbefore directed to be taken in Article 1, Section 2, Clause 2. Does that mean I'm constitutionally immune? It sure does. But you have to tell them and demand that it's a direct tax. You got to say it's a direct tax on my property. Now what are they going to do? They're going to come around and tell you this isn't under Title 26, this is under Title 27. And that really you're a coal miner, or you're a miner of some kind, or you're a manufacturing handgun someplace. Well, you ask them, all right, let's see the Form 4456. They'll send you the Form 4456, and sure enough, they're going to have you down under some excise tax where they're charging you under BATF for having some fraudulent claim that you're involved in mining or something that requires an excise tax, and that for the privilege of doing business, you have to pay a fee because you're a corporation, an officer of a corporation, or you reside in the District of Columbia. Now let's ask you, that's Section 6331A of the Code. Look up Section 6331A. Those are the only guys that the Treasury Department can levy against. That's the only ones. Are you any of those? No. How can that be? You're not any of those, they can't levy against you. If they can't levy against you, there's no jurisdiction over you. Got me? Does that make clear? I mean, if they could levy against you, they'd have jurisdiction. Now, if they levy against you and you pay them, guess what? You just gave them jurisdiction. You sign their documents, you sign their W-4 form, you don't put down there, like I told you, UD 1-207 without prejudice, guess what? You're in. So, you think. Now, isn't that fraud? Doesn't fraud void the contract? You need to read, folks. We need to get you down here, and we need to read. There's so many beautiful arguments in here. I mean, we can just hammer them. What is income? There is no income defined anywhere in the Code. Oh, Section 61A of the Code says income is wages. No, it doesn't. It says Section 61A of the Code says this is a list of sources from which income could be derived. Not necessarily is be, but could be. And it's compensation. Now, think about the word compensation. Look it up in Black's Law Dictionary. You're going to find out compensation, to make whole. Now, if you're out there and you painted your neighbor's barn, and he told you he'd give you $300 by Christmas, all right? You painted the barn, and Christmas came, and he didn't pay you the $300. Wouldn't you have a loss on paper? You would, wouldn't you? And wouldn't you have a gain? He would, wouldn't he? Now, let's say he pays you the $300. What do you got? Do you have a loss? No. Does he have a gain? No. What happened? An equal exchange of property. What happened? You changed your time of life property in labor for his consideration. You have a 0-0 balance. You aren't ahead and he isn't behind. And you aren't behind and he isn't ahead. That is compensation. That's what it means. To make whole. Now, what happens if he doesn't pay you? Doesn't he have a gain? He would have a profit, wouldn't he? A realized profit or gain. He got you to work for him and he didn't pay you, right? And you would have a loss, right? Does that make sense to you? Now, the only way you would have income, by the way they define it, in Brushenberg versus Union Pacific and some of these other cases, Pollock versus Farmers Loan and Trust, first you would have to have a realized gain from some source, right? Before the period under consideration happened. Now, did you get paid any more than you agreed to? You didn't, did you? You got paid $300. You agreed to $300, you got $300. If you got $301, you had a gain. And if you were a corporation, an officer of a corporation, and a person that resided in the District of Columbia was an officer of the government, you'd have a income. But you're not any of those. You're not a corporation. You're not an officer of a corporation. You don't reside in the District of Columbia as an officer of government. So you're, first of all, not even in the game. Second of all, you didn't receive anything above what you bargained for. Okay? So you don't have a realized profit or gain before the period under consideration was commenced, so you don't have any income. What you have is compensation. Before it can become income, it would have to be corporate property. You'd have to be a corporation, and you'd have to have a realized profit or gain. You don't have that. So don't tell anybody you have income. You ain't got none. Every time you volunteer to get in that, you get in trouble. Don't volunteer. Didn't they tell you that in the Army? Don't volunteer. You volunteer, you get the broom, and you get to drive it around the floor. Just ask me, I'll tell you. I know. Now, the bottom line is this. There's a lot of things that you need to know. The biggest thing is that you need to get a hold of one of these books, and you need to read it, cover to cover. And you need to be able to rattle it, just like I told you. And you need to trust your God in heaven above, in whom you should put all your trust and love. And you need to kick some tail and try and coordinate this. Program, format. You understand? Holy Bible? You got it? You need to get with the program. We can't keep screwing around like this, folks. You can't keep putting off till tomorrow. You can't keep screwing around like this, folks. You can't keep putting off till tomorrow. Because I'm going to tell you, there ain't going to be a tomorrow if you keep it up. You're going to have to get serious. Get hooked up on that radio station, 5.065 WWCR. Go down to Radio Shack. Get one of them 20 dB gain amplifiers to plug into your radio so you can make the thing work better. Plug that thing into your external antenna. It runs on a 9-volt battery. Put a damn... about a 3-inch strip of coiled solder on the tip of the antenna. Go outside, throw your fishing rod over the highest limb you can when the weight comes down. Take a roll of speaker wire, 100-foot speaker wire. You can get it at Radio Shack for $3, man. $3-4. Bare the end, twist it together, tie it in a loop, put it on the other end of that fishing line, pull that fishing line up in the air, get you a 100-foot antenna. Tie that baby off to your fence, come outside, take that wire, bear it off, and take it into your house and wrap it around the antenna on that 20 dB gain amplifier. You can pick up Moscow just like WXYT radio down across the street. You got a 100-foot antenna. You put on that 20 dB gain amplifier, and you're going to have your signal generating 20 times the force that it would before. So even if they jam the channel, you're still going to be able to hear, okay? You need to be listening to Radio Free America, to Jack McLam, to Tom Ballantyne, to Bill Cooper, to Mark from Michigan. You know, you need to get in touch. You need to get in touch with your God. You need to get in touch with your fellow Americans. You need to get down to the militia. You need to quit screwing around, sitting on the couch, watching a ball game, and the life going by, and nothing's getting done. You understand? You need to get out there and hit a couple of these patriotic meetings and listen to some of these folks talking that are trying to save you and your country. And you need to start realizing that you need to put your money where your mouth is. It's like, you know, put up or shut up. Because I'm telling you, if you don't do something soon, you're not going to have a country. What you're going to have is a chain around your ankle, and you're going to be pissed. So I'm telling you, the time is now. You know, you want to be a son of liberty or a daughter of liberty, the time is now. Do not put off till tomorrow what you can do today, because there won't be a tomorrow if you do. Just start putting one foot in front of the other, make up your mind you're going to do this, go get you one of these constitutions, and let's get serious business about America, and let's bring her back to the way she was. We need to pull that baby back into the wind and take that ship out. Leave that flag flying high, and we tell anybody to their face, you know, and we leave you to your proofs, pal. You touch my flag, and God's going to get you tonight. Don't touch my flag. Don't touch my country. Don't touch my Constitution. I'm going to wish you God bless America. We love you, America. I love Jack McLam's phrase, never to the New World Order. It'll never happen in your lifetime. You got to quit smoking that stuff. It ain't no good for you. You may think you're going to get away with it, but I'm here to tell you it ain't going to happen in your lifetime. You just keep wishing in one hand, doing something in the other, and see which one fills up faster. You're going to find out real quick. The United States of America is the most serious country in the world. Our people are the most generous, kind, and aggressive. And I'm telling you, we love our country, we love our flag, we love our Constitution, and we're not giving it up for anybody, especially a bunch of Yahoo bankers, okay? So, let them understand. Let the word go out and let them find out. We're not fooling around. So I'm going to wish you good night. God bless America. Long live the Constitution. God bless all of the fine folks that are standing up and being counted. God bless all the fine soldiers that have given their very life and are still, to this day, giving their life. Now, come on, folks. Let's not fool around here. You go down there and you grab a hold of one of these congressmen and let them understand, hey, I don't care what about your Bill 666. You're not changing the Fourth Amendment. You're not doing nothing. You got that? You want to get elected next time, you better listen up, pal. We might even just charge you right in an open court of law with an open indictment for treason. Now quit screwing around with my Constitution. Oh, I wanted to give that number out. We want to give that number out. We don't want to let that guy get away. We don't want to let that guy get away. Yes, sir. Let me get something here. Yes, yes, yes. Let me give you a number, folks. You need to call this congressman and let him understand. Say what? Say you gonna what? You be talking some heavy trash. We aren't gonna fool around with you. Here. We're not gonna fool around with you. God bless America. Let me get this beauty out here. Now, you're gonna get a treat. God's going to give you a treat tonight. This congressman's got this idea that we don't need the Fourth Amendment anymore. His name is Bill, or William, McCollum, spelled M-C-C-O-L-L-U-M. His phone number is area code 202-225-2176. He'd like to hear from you about the Fourth Amendment. You need to call him and tell him, do not touch my Constitution. Period. Do not change the Fourth Amendment, not even a little bit. We want our right to be free from an unreasonable search unless with a warrant, duly signed by a judge of the court, duly before a sworn magistrate where the guy swears that this is a true, in fact, case, this is the evidence to be seized, the person to be charged, and we want him to be able to hold that right up and say, we're not changing that today, sir. And if you got a problem with that, find another job, because you're fired. Got me?
We're all going to learn a new term. It's only 2 words. Now listen closely. Can all of you say constructive fraud?
Constructive fraud!
Did you ever get the feeling as you're staring at the ceiling that this game of life we play ain't fair? Seems as fast as we can make it, there's a hand that grabs and takes it till they plant us in a grave somewhere. Like a rodent on a treadmill, we keep pushing for it uphill, but we never seem to get too far. Well, if you think you're being taken, then you're ready to awaken to the truth of what we really are. We're all indentured, servitudal slaves, overburdened and bewildered feudal knaves, who have lost our sole posterity through ignorance and apathy, and now we're being taxed out of our graves. And as long as we stay passive, we'll succumb, contented with some socialistic crumb. Well, the naked truth and fact is we're all saps who pay our taxes, and that is why the banksters keep us dumb. Could the state of our condition be the product of omission, what we didn't learn in public schools? And did our fathers all through history all fight and die for liberty so we could play the tyrant's fools? And can you call it education when it's all indoctrination to obey the hidden powers that be? Did we fight the revolution? Did we win the world wars just to slumber into slavery? We're all indentured, servitudal slaves, overburdened and bewildered feudal knaves, who have lost our sole posterity through ignorance and apathy, and now we're some humanistic crime. Well, the naked truth and fact is we're all saps who pay those taxes, and that is why the banksters keep us down. While Franklin and Eleanor were telling us they hated war, they made a deal behind our backs. They said the bankers could enslave us for a portion of our wages, and today we call it income tax. But what they failed then to tell us was the way they planned to sell us into statutory slavery. Now it's called constructive fraud. Some even claim the wrath of God. I call it social insecurity.